sat on a bench outside a state courtroom to decide how they wanted a judge to control the courtroom and the people in and near it. That's not what they did at all. The hell kind of opening sentence is this? This was like the LeBron James of lawyers. And his lawyer out of her courtroom through a non-public jury door, her back door. Just say it. Just get it out of the way. Just call her Backdoor Judge Dugan. We all say it. It's like if it's on the docket and she's inside her courtroom and she's in a robe, she can do whatever she wants. She could do lines of coke with this dude if they wanted to. Backdoor Dugan trying to find a back door out of her criminal charges. You can see that her defense team submitted this motion to dismiss her case. And if you are unfamiliar with this woman, this is her. She was put on temporary leave. She's a Wisconsin judge charged with 2 counts, obstruction of justice, concealing to prevent the arrest. And that's because she took this illegal alien out her back door, right in her courtroom. She got criminally charged, and this guy was also charged with 3 counts of battery for beating the hell out of people. They were sitting in the courtroom, and she's hired a ton of lawyers like this dude who are coming in, the LeBron James of lawyers, trying to get her out of trouble. She's been charged in the Eastern District of Wisconsin, and now she's trying to escape criminal liability. Now let's go through her motion to dismiss and analyze this puppy, because we know that the immunity issue is going to come up because the liberals say that they are above the law for everything they do, but everyone else is not. And we've already seen, we know that there is judicial immunity. We know cops have qualified immunity. We know Congress people have legislative immunity. We didn't know much about presidential immunity. They told us that there was no such thing until the Supreme Court said, oh yeah, there is. Obviously, idiots. Something we have been screaming about forever. There's clearly immunity. But then the Supreme Court gave us 3 buckets. And so we'll use this as a framework. Let's draw these out because we're going to analyze Dugan's claims according to these 3 buckets. So we'll just draw these out. Remember, the Supreme Court said, look, when we're asking whether there is immunity, we have to ask what bucket it goes in. The first bucket, we're going to say that the strongest constitutional protections go this way. So immunity is stronger going this direction on your screen to the right. You can have complete, and we'll call this absolute immunity if the Constitution, if the laws, if the rules say you can do that thing explicitly, okay? So if the law says somewhere that Dugan can sneak aliens out her back door somewhere, she's going to come into this bucket. We're unlikely to see that, I think. Now, we also have this other bucket. It was called the presumptive bucket. If the person, in this case, this applies to the president, but I think we'll probably see a similar kind of distinction on a lot of this in this case. Presumptive would mean it may not be concrete, like explicit, saying that you can do this. It's not codified, written deliberately in the Constitution. So it's maybe not absolute, but it might be presumptive if it's within the outer perimeters. Okay, so if you can make an arguable point saying, actually, my power is within this little, bucket, like this is clearly constitutional. This is my outer perimeter of power. Then I'll be protected. I'll have a presumption of immunity, and then you can rebut that immunity. Say, actually, we think your action was out here. It was outside the outer perimeter, and so therefore you fall into this bucket, which is no immunity. Okay, this is you don't get any immunity at all because your actions were outside of the force field, as it were, of protection. So now she's going to claim judicial immunity, and we're going to be asking ourselves, did her actions, were they more over here? You can just plot them here like Battleship, or were they not immune? Well, her actions over here in this bucket. Let's see what her attorneys say. They write, all right, this is the defense team, Backdoor Dugan, in her defense writing this. They say, this is an extraordinary prosecution of a judge that poses a threat to federalism and judicial independence from Trump. In practical terms of American government design, consider starkly what it proposes. They said this. Oh, this is great. One morning, plainclothes federal agents with badges and baseball caps, ICE folks, sat on a bench outside a state courtroom to decide how they wanted a judge to control the courtroom and the people in and near it. That's not what they did at all. The hell kind of opening sentence is this? This was like the LeBron James of lawyers. The agents decided how they wanted a judge to control the courtroom. She came outside the court. She approached them for not doing as they wish. The judge faces now federal criminal charges. That is like totally inverting what happened. We watched the video. They were sitting outside. They didn't even go into her courtroom. She came out to them. Judges, like legislators and executive officials, are not above the law, except she is, but they do enjoy judicial immunity. That's rich, right? We're not above the law, except in this case, with deeper roots than the republic itself. Now, the Constitution also makes the federal government the supreme sovereign, Dugan's defense. The framing generation was wary of giving too much power to the federal government, we know. The prosecution is barred by judicial immunity, long rooted in common law by the 10th Amendment, saying that we have a vertical separation of of power, and that the court can avoid these questions by saying that this statute, okay, that the law under which she's being charged for obstructing and concealing doesn't apply to official acts of state court judges. Okay, so now you see official acts. So to our buckets, she's saying I'm clearly in this bucket. My backdoor use with this illegal is absolutely official, immune, and protected. Okay, that's where she's going with this. Now, unlike the only statute the Supreme Court has found to abrogate a judge's immunity, they weren't enacted, and so now you have to decide accordingly. Here's what she writes. Because Judge Dugan, Backdoor Dugan, rightly asserts judicial immunity and the 10th Amendment, you should not even engage in fact-finding. Don't even have a hearing on this. Just say the law doesn't apply to her. She's above the law. A bar-like immunity blocks proceedings at the outset, right? And we've talked about this with the Trump case, because if Trump has presidential immunity, and if she says she's got immunity, then it should preclude you from the entire process, right? Because the process is the penalty. You don't get immunity just after the end of the conviction, as we saw with Trump. We're like, he shouldn't even be prosecuted here. But the judges didn't want to go through that analysis because it would have been devastating to their case, which is why Trump ultimately got convicted. And he's appealing that because Merchan didn't pause the case like Judge Chutkan did to let the Supreme Court handle the immunity issue. But the court, writes Dugan's defense, must decide whether this indictment falls within a judge's official functions at their perimeter or altogether outside the official duties and powers. Okay, 3 buckets. Didn't even know they were going to give that to us, but there it is. Only acts that are wholly or partly within the official functions get immunity, as we'll explain. She says she takes this indictment allegation at face value. Now, they're not all accurate, but you can assume them true because we want to dismiss this case. It says here, this is what they're alleging. The first count says on Good Friday, nonetheless, on a Backdoor Dugan acting like this on a Good Friday. Can you believe that? April 18th, they say Judge Dugan knowingly concealed a defendant called that illegal, EFR, who appeared that morning in her courtroom aware that a warrant had been issued for his arrest. Now, that count offers no detail. So, okay, she concealed this dude. But the second count does. It says it's about the same guy. The count accuses her of corruptly endeavoring. They say, oh no, she wasn't corruptly endeavoring to influence, obstruct, or impede the due proper administration of the law under which, quote, a pending proceeding, which was the administrative arrest of the same man, was being had by the feds who were there. Dugan supposedly confronted ICE agents. We watched it. It's on camera. And told them falsely that they needed a judicial warrant, which they didn't. Then directed them to leave the public hallway outside her courtroom to go to the chief judge's office a few feet away, which is not a few feet away. We watched them walk it. She then addressed the defendant's case a few feet's like a yard off the record while some of the agents were in the chief judge's office. Next, she directed the defendant and his lawyer out of her courtroom through a non-public jury door, her back door. Just say it. Just get it out of the way. Just call her Backdoor Judge Dugan. We all say it. Causing him to emerge into the same public hallway, right? So she led him out to bypass the agents, which she moved down the line. She finally told the defense lawyer that he could appear by Zoom for the next court date. And then she didn't even notify the prosecutor who was in the courtroom. Prosecutor was going, wait, I got my victims back here who got their heads beaten in by this lunatic. And she just continued the case and said he could show up by Zoom next time because illegal aliens in America, they get better benefits and better privileges than you. They don't have to have licenses when they get stopped by Tennessee Highway Patrol. They don't have to get investigated by the FBI when they're trafficking humans. They don't have to get arrested or served with orders of protections when they beat their spouses and threaten their kids. And then they get backdoor access to judges. Now, the day before the arraignment, Judge Dugan moved to dismiss this indictment as barred. She says, I'm above the law. I have judicial immunity. And by the allocation of power retained by the states and denied by the federal government, and she's renewing that now. She says, I have a lot of immunity. You know, judges are special. By 1607, judicial immunity would have barred this prosecution in England. Well, we're not England, so we don't care. Since at least the early 17th century, English judges have been immune. It continued up to the Civil War. In the aftermath of the Civil War, we got a bunch of amendments. There was an innovation. John Bingham, the drafter of the 14th Amendment, passed the Reconstruction Amendments, and in 1871, the Supreme Court did a bunch of other things. But the court, lots of case law here. You can just explain what her defense is. We don't need the book report, LeBron James lawyer. This is why you know this is probably pretty weak here, because we're getting a lot of copy and pasting from other areas. This case, by any measure though, her indicted conduct is within the core of a judge's official acts and immunity, okay? Far right bucket, an illegal out the back. Here, the government prosecutes her for official acts themselves and only for her official acts. The charged acts are devoid of the self-enrichment. She's not enriching herself. Yes, she is. Politically. Or self-gratification. Yes, it is. That's what what this whole thing was. She was enjoying herself too much. That marks earlier cases in which judges were convicted for using judicial status as leverage. Like, she didn't get a kickback. She didn't get a bribe. She didn't get a favor. She didn't do another crime. She got the enjoyment of fighting Trump's ICE people, which is plenty for them. And they did not trench on any other rights. Now, on the indictment's own terms, Backdoor Dugan's defense says, her every action related to a pending case. Okay, see, so you have to get very granular here. Every action related to a pending case assigned to her branch while she was on duty and she had her robe on. So like she was on the clock and she had a robe. Every action concerned the people that were scheduled to appear before her that morning. She sought to ascertain what legal authority, if any, federal agents had to snatch from that courthouse a defendant with an active criminal case in her branch. Those agents were outside her courtroom. They acknowledged that. They never went in the court. They're in a public hallway outside your courtroom. You have no power there. In the public hallway near the doors, admitted by her defense, because it's true. Her acts concerned directing some of the agents to the chief judge, who by appointment of the state Supreme Court had the greatest administrative authority over the whole courthouse, right? She was distracting them and moving them out. Now, the indictment describes actions concerning how and when the judge handled a defendant's appearance in court within the parameters of her morning docket and calendar. So this is pretty interesting. It's like if it's on the docket and she's inside her courtroom and she's in a robe, she could do whatever she wants. She could do lines of coke with this dude if they wanted to. Her actions concerned what flexibility she would allow for him for future appearances. Or they concerned which courtroom door he would use to emerge into the public hallway. That's all. It had no ulterior motive. It was just more convenient for him. Though through the doors at the end of the courtroom's aisle, or instead at most 15 feet away beside just one of the courtroom's interior walls. So maybe they couldn't do coke because that doesn't necessarily pertain to the future case, but because she was managing the caseload, and essentially the prosecutor should be very upset about this because he got his case kind of stolen from him without having his input that day of the hearing. The judge just vacated it without him knowing. So all of these things, right, are causing harm to other people in the courtroom who also have rights. Like the victims are there, they want to be heard. They're there because they got their heads beat in. So the judge, it's not just like her managing her private docket, in other words. It's not like the court's not in session. There's no other parties there who have rights. The state government has a right to be there and be heard on this. So there's other parties involved. In other words, like she's not like, I'm sick this morning. Okay, sometimes judges are sick. They wake up, I'm sick, I can't come into court, docket's scheduled, everything gets continued, or another judge will fill in or whatever, right? So if something like that happens, you might say that is within her discretion, but there were 3 victims there, 2 victims there, plus the victim's advocate and the prosecutor all in the courtroom. So it's not just like she's managing his future appearances. There was a scheduled hearing on that date. Maybe the victims wanted to say something. That's why they're there. The indictment includes no hint of self-dealing. Well, it is her enthusiasm for being a judicial insurrectionist, okay? And that is satisfactory enough for her. Now, it includes no hint of bribery, extortion, kickbacks, tax evasion, stealing, assault, or other extrajudicial misconduct. No hint of unlawful coercion, threat, or thuggery. I would disagree with that. No hint, in fact, of any ultra-virus exercise of ordinary judicial power. I would say yes. I would say it is ultra-virus. The prosecutor didn't get a say in it. It was an ex parte action, essentially. It was an ex parte continuance that was violative of the victim's rights and the government's rights. It was ultra-virus that they had no say. In her courtroom, they were all there. She just moved it. Although the first count echoes the statute's reference to concealment, nothing in the indictment suggests actual concealment of anyone or anything. You put him in the back door. In sum, nothing in this indictment sounds like a claim like unofficial acts and extrajudicial self-dealing that have sent them, other judges, to face federal criminal trials. And I think that's probably true. Like, I think other judges were doing bad things too, but this is just a different bad thing. I don't know, maybe there's more to it. Bribery, extortion, kickbacks or something. I don't know. Maybe she's friends with the defense team. I think that maybe she just kind of saw herself in him. I think there's a kind of a resemblance there. You know, this is the guy here. She's like, oh, gosh, I just see a lot in him. She's inspired by him and empathized with him and wanted him to do well. And she's like, gosh, we're like almost like twins almost. So it was very animated about this. And that was satisfactory enough. That was very satisfying to her. Now, most importantly, the indictment says nothing within the scope to which Congress could have eliminated judicial immunity for her. Nothing in the indictment says that she violated any individual's constitutional rights, not even close. The indictment didn't allege it, but she did it in the courtroom. There were victims who were there. And the federal government itself has no right to get rid of judicial immunity. And so to the contrary, they say the Supreme Court has granted her immunity, that the federal government has indicted her only for doing what judges may do as a matter of official acts, right? Her defense is, he used the door in my my courtroom. He's allowed to use doors in my courtroom. We continued his case because I'm a judge and I can manage my calendar. It's an official act. Everything that she did was allowed. Now, usually when lawyers or judges speak of the separation of powers, they refer to the allegation of core duties, and there's another separation of powers. Again, a lot of legalese here. Here, the Constitution's vertical separations of power means that the court must assess whether the federal government can actually exact criminal charges from Dugan for doing in and near her state courtroom as the indictment contends. That's the core question here under the 10th Amendment. And the government, they say, cannot prove this. The Supreme Court sustained someone else's claim of immunity in this case, a bunch of other cases, and this is just like that. They say this case is just the ordinary work of a state court. It's unlike anything strange in other cases that's illegal. She had authority and control. She's a duly elected judge, and if you got a problem, hit her with an ethics complaint, but don't charge her with a crime. Other cases are much worse than this, and she's not that bad. This case is not akin to other things, and the federal government is trying to punish her, but the 10th Amendment says they can't do that. So you have a duty to dismiss this case. The correct time, dismiss it now. And it's hilarious. They keep referencing the Trump Supreme Court case, which is great. For that matter, even if hypothetically the government could point here to an unofficial act, it could not use as evidence some other case. And so there's a constitutional avoidance doctrine, which is wild they would invoke this. Although Dugan says she has immunity, you shouldn't test it because we should owe a deference to branches of government, saying this indictment breaks new ground. Dismissing it will not. For a long time, judges have had judicial immunity, and Backdoor Dugan deserves the same. So do the limits of federal power and saying this court should dismiss the indictment signed by the defense attorney for Backdoor Dugan, Dean A. Strang. And, I think that it's a defense. I think if you get a friendly jury in Wisconsin, they might buy that defense. Oh, it was her courtroom. But I think the video, when you watch the video and you see what her intention was, like you can splice her case up, right? And go through each action. And all of the actions outside the courtroom, the walking them over, the continuation of the case, the violation of the victim's rights, the not even talking to the prosecutor about this. And by the way, Dugan got busted by everybody in her courtroom who knew what was going on. Even the security guy, sounds like, went out and warned the ICE agents. So like every single witness who's going to come in here, all the ICE agents will testify. We know what she was doing. They may even want to subpoena the administrative judge. What were they saying to you? Tell us about your conversation. And even the security guy, right, was there, warned them. He's going to come in and testify. Everyone's going to know she's whispering. She continued the case. She had an interest in stopping Trump, just like the rest of the libs who think it's okay to break the law, to do whatever they want to do. Now her defense team is putting together what they can put together, but we know what she did. She knows what she did. The fact that they're going to try to say this is an official act, which is in this protected bucket, is going to be a fun battle. We're going to keep our eye on it with Backdoor Dugan out of Wisconsin. Thank you for subscribing and joining as we do.